Hi there. Yet again, we have more information and more questions. Honestly, I can't thank you guys enough for sending your comments, giving us the feedback, and asking questions that really do prompt us to dive in, dig a little deeper, and see what all we can find out to try and help resolve what is this property tax crisis that is taking place right now. So one of the questions that keeps coming up, and I'm probably even guilty of it myself, is saying that this is unconstitutional, this should not be. So we did a dive into this and wanted to look specifically at our Ohio Constitution for those property tax provisions. And in Article, we'll call it Article 12, Section 2, this is where the uniform rule and tax limits are noted. And it indicates specifically, land and improvements thereon shall be taxed by uniform rule according to value. So the uniform rule is applying to the property that must be taxed on its value, and that it is applied equally. So one property shouldn't be based off of a different valuation than another for one person versus another, and etc. So as long as it's equal, this is how it's supposed to be ruled. This does allow for some exceptions, what we call exemptions, when it comes to agricultural land. That's a current agricultural use valuation, or CAUV, mini farms, things like that, acreage. And then also charitable, educational, or property that is owned by government entities. Those are all exempt typically. And then of course, homestead exemptions is another one of those qualifiers that could have a different basis. So Section 2A actually talks about homestead exemption that was added later than the Constitution was originally done by an amendment. This authorizes reduced property taxes for those elderly and or disabled homeowners in their primary residence. Now Section 2B, this one is interesting. It sets a 10 mil limit, which cannot go higher than a 10 mil limit, which means our overlapping local governments, cities, schools, any of those school districts, libraries, special levies that we hear about, that is supposed to be stopped if it exceeds a 10 mil levy, unless we go in and it's the voters say, yes, we approve it. So there's been some conversation about a 20 mil limit with one of the new proposed bills, and I just want to make and draw your attention to this, that currently our Constitution says a 10 mil limit unless it is voted on in a levy above that. So if now there is a proposal trying to change that to a 20 mil limit, understand what that means is that they have double what our Constitution said, and then they have to get our permission and we vote it in or vote it out. So please pay attention to this language, because I think that is a very particular point that is not being discussed openly. So if our Constitution says it's a 10 mil limit, then anything above that needs to be voted in. I don't want that language to be changed that automatically doubles it, and then we still have to vote if it's more than that. So just be cautious. Section 6 deals with the state debt limitations, and it prevents the state itself from levying property taxes directly to general revenue purposes. So property taxes are primarily for a local revenue source, not at the state level, although it is governed by this state law. It gets confusing. I understand why. We all don't know what's going on. If everyone's property is assessed fairly at market value, then that controls the uniformity aspect. If voter control dictates any levies that go above a 10 mil limit, then that's how we pay more than what our Constitution would allow. And exemptions that are allowed allow for special exemptions such as homestead, charitable uses, and obviously our government. The local burden is that the state doesn't collect property taxes for its own revenue. Instead, the schools, counties, cities, townships, etc. are relying on that money. So why are property taxes jumping during reappraisals? The values increase, so the taxable values increase. So if there would be a cap on the growth, that would help prevent this, as well as that 10 mil limitation. Voters are constantly asked to approve new levies for schools, parks, fire, etc., and local governments are boxed in by those limits, so that's why they push it to a ballot. Calls to abolish our property taxes would require a constitutional amendment, which is what we're trying to do. Now, the other big part of this discussion is residential versus commercial properties. And yes, while the Constitution says land and improvements thereon shall be taxed by uniform rule according to value, this does apply to all property. So it's residential, it's commercial, industrial, and agricultural. It means both homes and businesses can be assessed at their fair market value and then taxed at that same rate within the taxing district. Whenever there's a discrepancy and something else applied, then that's where we start to question. We talked about homestead exemptions, we talked about the CAUV, and the other distinguishing difference is that with commercial, there is no homestead and there is no CAUV benefits. So that right off the bat is only applied to residential properties, not applied to commercial. However, subject to the same uniform taxation for commercial doesn't mean that they don't get an economic development abatement. That's where we see home developments get benefits of being tax exempt for a set period of time. New businesses coming in may waive tax collections for a set time, and this is all authorized by state law for enterprise zones and TIFs and things like that. That 10 mil limitation we also talked about, it applies to all property, residential and commercial, but local governments can only levy up to 10 mils unvoted. Anything above that has to be done through levies or bond issues, as we've mentioned. So residential homeowners feel the burden most acutely because they can't pass property tax cost onto tenants or customers like a landlord or a business would be able to do. And commercial properties are taxed under the same uniform valuation principle, but they may get to negotiate abatements or credits, which shifts more of that tax load onto the homeowners. So yes, Ohio's Constitution property tax provisions apply to both residential and commercial properties. The exemptions for homestead and CAUV only apply to individuals and farmers, while special abatements, like for development projects, only tend to benefit businesses. Now here's the real sticking point. The Ohio Supreme Court has weighed in many times on property taxation issues, but to date, they have not declared residential property taxes unconstitutional. Instead, it does uphold that the state's constitutional framework under that Article 12, Section 2 allows for uniform taxation of real property by value. Now, where is there the question coming up? The Cincinnati School Board of Education versus Walther in 1979 had parents argue that Ohio's reliance on local property taxes for school funding violated the U.S. Constitutional Equal Protection Clause. The court upheld the system, finding there were disparities caused by different tax bases being unconstitutional. This case was a precursor to later litigation, but established that property tax funded schools weren't inherently unconstitutional. So in DeRolf versus the state, this was the landmark case where the Ohio Supreme Court ruled the state's system of funding schools dependent on local property taxes was unconstitutional under the Ohio Constitution because it failed to provide a thorough and efficient system of education. So this is very important. The court did not strike down property taxes themselves. It ruled the school funding system unconstitutional. Property taxes remained valid, but the state was ordered to reform school funding. What does this mean? The court has repeatedly reinforced that residential property must be taxed uniformly and based on true value in money. And challenges have come up when counties use different valuation methods or reassessment cycles, but the court has consistently upheld the constitutionality of property taxes as long as they follow that uniform rule. So here's the bottom line. The Ohio Supreme Court has never ruled residential property taxes themselves unconstitutional. What they have ruled is that school funding reliant on property taxes is unconstitutional. The uniformity rule requires all property to be taxed consistently based on value. Hope this clears this up, and obviously it still opens a whole lot of parameters when we have counties that are saying their systems are flawed, there were errors, there was a set number of homes that were determined valued differently than others. I think that would open the door to maybe come back and have further discussion on this. Of course, I'm not an attorney, nor am I giving legal advice. However, I'm just saying that if these are the rules and the precedent that has been set in the very clear but vague language, then maybe that's the sticking point, is that the uniformity rule and the matter of value, how that is determined, is what we have questions on. Hope this helps. We'll continue to dive in and answer your questions. And so technically not unconstitutional, but somewhat unconstitutional. Who knows? Let's just figure it out and find a better answer.